case on this morning's docket, number 114675, State of Kansas v. Darrell Broxton.
Okay, please, court, counsel, Corey Call, appellate defender, representing Darrell Broxton. I request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Peter Belmont was a successful man in Wyandotte County, and he would frequently go into Kansas City, Missouri, and befriend some homeless men. He would take them back to his house, and they would do help him with chores around the house, and sometimes that relationship turned into a sexual relationship. And his friends warned him this was a bad idea, that he could be in danger of doing it, and it turned out that he was discovered in 2012. He had been killed, and his home had been robbed. The state charged Darrell Broxton with first-degree murder, burglary, felony theft, and misdemeanor theft, burglary of a vehicle. And at trial, Mr. Broxton requested an instruction on felony murder. The judge declined that, said it weren't facts to support it. And the jury, but they didn't give the lesser of second-degree intentional. And Mr. Broxton was convicted of second-degree intentional murder and burglary and the thefts. We raised 4 issues. The first was that the district court erred in failing to give the felony theft, the felony murder instruction. There was a murder down in Florida that Mr. Broxton was arrested for, and the police discussed him, but the state of Florida decided not to prosecute him, and that came in as 455 evidence. And in Florida, the prosecutors give notice that they're not going to pursue charges. I forget the exact name of it, but they file a notice of that, and the defense wanted to introduce that notice to say, well, yeah, there was this crime, but the state chose not to pursue it because they couldn't prove that his alibi his story was not right, and the district court denied that. So we challenged that, and there were 2 sentencing issues. It was a Dickey issue and what I'll call a Buell issue. I went to the Court of Appeals. The Court of Appeals, the majority said that the felony murder instruction. Let me start backwards. I'll start backwards. They said that Dickey applied. I don't think the state has any problem with that, so that it is not an issue. The Florida burglary was a Florida burglary that was counted as a person felony, which this court said in Buell should be scored as a non-person felony. And this is Mr. Broxton's direct appeal, so Buell applies. The state can test that. And so then going directly to the felony murder issue, the Court of Appeals, the majority opinion said it wasn't factually appropriate, and the dissent or the concurrence said it wasn't legally appropriate because prosecutors can choose what to charge, and didn't comment on the factual appropriateness of it because he didn't have to.
Address the concurring opinion. Why isn't it just the discretion of the prosecutor to charge the theory of the case and how they want to proceed? And here they proceeded on premeditated first-degree murder, and then the lesser included of second degree that follows from that. But they didn't charge felony murder. Why? What's your basis for saying it should have been required?
My basis is
based just on the prosecutorial discretion that exists in these cases.
The prosecutor has discretion to charge of what crimes to charge. And I'll say this: the late Chief Judge Richard Green, when he was in the Court of Appeals, sometimes he would say, "That's a very seductive argument, counselor," and that was always made you feel real good when he said that. But and I think this is a very seductive argument to say that, because the argument is that, well, it's a different crime. The statutory elements are different. The punishments are different. It's really a different crime that needs to be charged differently. And I think that argument's attractive to me because I have made that argument at this very podium several times, and this court repeatedly has told me they're not separate crimes. It is first-degree murder. That's what it is. It's one crime, and and that's how you can cobble it together. You don't have to charge different crimes. And so the prosecutor has discretion to charge first-degree murder or not charge first-degree murder. That's absolutely right. But if they charge first-degree murder, then they have charged the crime of first-degree murder, and there are alternative means to that. And the prosecutor doesn't have the authority then to restrict within that means. It's like we can't pursue this little bit of it. That's not part of the charging, because that's what prosecutors really have control over, is the ability to charge and give the authority to the court to these crimes.
So you're not saying that felony murder is a lesser included offense of first degree premeditated. You're saying it's the same thing?
It is the same crime. That's what this court has said in Young, because in Young, the defendant was charged with first-degree premeditated murder. That's what it said in the charge, first-degree premeditated. And he was convicted of felony murder. And the defendant said, well, that's not what you charged me with. You chose premeditated murder. And this court said, well, no, what they chose was first-degree murder. That's what they chose. And then there's these different means, and the evidence supports it and all that. It's not a different crime. They don't have the authority. Then it just becomes, so is it legally appropriate to charge? Can the court charge that? And yes, the court could have given the instruction. It was legally appropriate because it was authorized by the charging document. I guess that's how I look at legally appropriate. Is it authorized by the charging document? And it is. The state filed a charging document, first-degree murder, and it was authorized by that. And therefore, it was legally appropriate. On the factually appropriate, which is what the majority of the Court of Appeals said, the state's theory was that Mr. Broxton killed Mr. Belmont, and then in order to feed his drug habit, and then took his stuff. The Court of Appeals described it as, in essence, the trial court's interpretation of events was that Broxton killed Belmont and then went to work gathering up Belmont's things and attempting to open his safe. Based on our reading of the record, this is a reasonable interpretation. That sounds like felony murder to me. He killed him in order to take his stuff. And there was, the point of the Court of Appeals was, well, but there was, nobody saw anything happen. There was a period of days when we think that Mr. Belmont was dead, that then so we don't know when the thefts occurred during that, so we don't know. But that doesn't seem to be the sufficiency argument that we usually come up with. I think if the court had instructed on felony murder, and I was up here arguing there was insufficient evidence of that because we don't know when the stuff was taken, I think the court would say, well, there's circumstantial evidence that he killed him. Someone was trying to get into the safe, stuff was taken, his van was taken. It seems like the court would say that a jury could find this. And so it was factually appropriate.
Why does it matter when your client was convicted of an even lesser degree?
That's right. So the question is prejudice, right? Because normally, if you're convicted of a lesser, all issues with the greater go away. But in this case, when I filed the Court of Appeals brief, he was criminal history A. And so his sentence, rather than getting the hard 20, facing the hard 20, a life sentence with a hard 20 that he would have received had he been convicted of felony murder, he got 600 some odd months. Now that's been reduced because of the Dickey, went down to B. And I think if this court applies Buell, he will be a C, and so which he faces a max of 285, which is still more than the hard 20, which would be 240 months.
Is it really more?
Sounds like more. The 285 is the minimum there, and according to Aline, we look at mandatory minimums. It's not the life, it's not the max, it's what's the minimum. And he could face more time. In this, and it's not necessarily a hypothetical.
So you're in the odd situation of saying your client would prefer to be convicted of the greater crime. If he has to be convicted of one or the other, obviously prefer not to be convicted at all.
That's right. And I would say it gets a little hinky when we're talking about remedy and what he's going to be convicted of. Because if he went back, he was acquitted. He was convicted of second-degree intentional, which means that he was acquitted of first-degree murder. And if I'm right, those are one crime, then they can't charge him with felony murder upon remand because he has been acquitted of that crime.
Then how does the error, assuming there is error, matter?
It matters because this court, I think, looks at, did he receive a fair trial?
Well, we look at the impact on the verdict.
That's right.
of the error. And
That-
if your argument is the only thing that can happen here is a retrial on the second-degree murder conviction, that's what he got.
Right, but I don't think that's the analysis. I think the analysis is, did it affect, not the verdict in the future, not the verdict for him, but did it affect, did when he was tried, did that affect the verdict in his, in that first trial? I think, in other words, could he have been convicted of a felony murder? And yes, he was, and he would have gotten less, he would have been facing less time in that situation. And so that's the harm there. So was that a fair trial? No, it was not a fair trial. Now, if he goes back and he gets resentenced for, and he gets, and in that trial, they don't instruct on felony murder, is that unfair? Well, no, that's not unfair. Because under the rules, how the rules work in that particular trial, he's not exposed to felony murder.
The trouble I'm having with this, it seems to me that your position, you wouldn't be here arguing if he's a criminal history I, that you want him retried felony murder because he'd be doing less time for what he was convicted of. So
That's
what you're
right.
arguing is completely dependent on something that's not before the court, has nothing to do with the elements of the crime or anything like that. It's just what his criminal history is. And that just seems like a strange, a very odd basis to be motivating your appeal here. I don't understand that. You're arguing for a greater crime because it results in lesser time because of your client's criminal history. It makes it an off-grid as opposed to a grid.
That's
And
right.
I understand it's kind of a consequence of our guidelines, and there's times when a lesser severity offense results in more time, but that happens. But that's what you're arguing here.
That is what I'm arguing, and I think
just-
if we're looking, did it prejudice the defendant? I think saying that he has to spend an extra 45 months in prison because of this error. Well, that's a real prejudice. I mean, sometimes we talk about prejudice. Well, it affected this juror, the opinion of this witness, or it prejudiced this. But here, what we're talking about is we can look and see it's 45 months in prison.
But isn't that speculative? Because it could be life. You're looking at the mandatory minimum.
Right.
That's right.
And-
That's right.
But you're putting your client at risk to spending 25 more years. Or more. I don't know what his age is.
Yeah, he's in his 50s.
Okay, so,
Yeah.
And so how can we say that he is harmed by that?
I think you can say he is harmed because his, you look at, according to Lean, I think one of the things you look at is the mandatory minimum. That's a very real impact of the sentence. And that is that he would have gotten if he convicted, he would have gotten a hard 20. And if you look at what is his exposure in this case, and it is 285 is the top of the box. And I think, and yeah, there's it could be more, and there is a risk to Mr. Broxton, and I think that's his risk. You can't say for sure that he was prejudiced by this, but I think you can say that if we're not sure, then he certainly he was facing 45 more months as a possibility of this error. And it's difficult to tell Mr. Broxton that is harmless, because it could be more. He's looking at 45 months, and especially at his age, those are important months.
Counsel, we've used up some of your time with our questions. You're out of time. Do you need 30 or 45 seconds to kind of summarize? You want to wait till your rebuttal?
Well, I think I'll take it now, just and you never know if you want to come up. Waste your time. I think the question is, as far as whether he was prejudiced, and especially whether or not, if you can only go back for second-degree murder, whether or not you can actually, whether there's anything at issue here. The key I want the court to remember is that the question is did he get a fair trial? Did he get a fair trial? Was there error, and did that error affect the verdict? And I think unquestionably the answer to those questions is yes. And in that situation, I believe this court reverses for a new trial because he was prejudiced by the error.
Thank you, counsel.
Thank you.
May it please the court, Ethan Ziff-Sigler from the Wyandotte County District Attorney's Office. I want to start briefly with the criminal history issue. We are conceding the Dickey issue on the Kansas burglary, but however, I believe the analysis the defender's office has provided on the Florida burglary is incorrect. This is not a direct sentencing appeal. In fact, his sentence was challenged while this case had been noticed to appeal on a motion to correct a legal sentence, not directly. And that makes a huge difference. Because it was challenged as a motion to correct a legal sentence, Buell does not apply, Murdoch 2 applies. We're not in the world of Wettrick and identical to or narrower than. We are in fact back at Williams, which is most comparable offense. Because of the procedural nature of this case, it is not a case where Wettrick and Buell apply.
Why not?
Because he challenged it as a motion to correct a legal sentence, not a direct objection to his criminal history at the time.
But we're on direct appeal here, are we not?
Right, but because he's saying that his sentence was illegal, not a direct appeal, he didn't object at the time. He said that the sentence you sentenced me to is illegal. The threshold question is Murdoch 2, is what at the time he was sentenced, was that sentence that was imposed illegal? Because he did not object, because that sentencing went through, and because it was later challenged collaterally.
So that's making a preservation argument. Sorry, you're just saying the argument that might get him relief on direct appeal wasn't made, so it's not preserved.
Correct. And the argument goes to the question of whether or not it's an illegal sentence, because that's how this was challenged. And that makes a huge difference.
When was the previous cases making that distinction, though, have been motions to correct that followed the end of direct appeals, right?
I believe so, and I don't, because I
too.
don't know the procedural history. That's a question I'm not comfortable answering 100%.
It's a genuine question for me too. I don't know the answer. I'm not trying to trick you. I really wanted to know. Here, when exactly did the motion happen?
The motion happened after his sentencing, and the original notice of appeal was filed, but before the appeal was docketed.
Okay.
So
Thanks.
procedurally, the district court still then had jurisdiction because the appeal hadn't been docketed.
Right.
But I do think that makes a difference. They are saying that his sentence was illegal when it was imposed. This court has said after Murdoch 2 that Wettrick does not apply, does not make previously imposed sentences illegal. Therefore, Buell, which was decided the same day as Wettrick and applied Wettrick to the Florida burglaries, does not apply. Williams is still the governing law, and it is still a person felony. So I wanted to just briefly start there.
Under Wettrick, there is still a sentencing error, but that claim is not preserved in the direct appeal. That's
Correct.
how to summarize your argument, right?
Yes, Your Honor. That is absolutely how I would summarize it. So I will work just briefly backwards on the 6455 issue. I do believe it was appropriate for the court to leave out the prosecutor's opinion of the prior case. Unlike a jury verdict,
I'm sorry, I have one more question about
Sure.
exactly how the issue ends up before us on the Wettrick issue. So the motion got filed, and once the motion got filed in district court, and then the docketing statement got filed, did the legality of the sentence get added as an issue in the docketing statement?
That I'm not sure of. It was
Okay,
not
if it was, does that undercut your argument?
I don't believe so, because it still presents as a motion to correct a legal sentence. I will say, I was trying to get the procedural history right. I believe it was not included in the original docketing statement of the direct appeal, that it was
That's what I
later
was trying to
added
get to.
in.
But it
And of
was,
course, we don't have binding docketing statements still.
Yeah.
So
Right.
and it was an issue in the brief
Correct. But
for the Court of Appeals, so.
correct, and I think it's preserved as all motions to correct a legal sentence are preserved, that they can be corrected at any time, but my answer to that is that's how this court should treat it, as a motion to correct a legal sentence, not a direct sentencing appeal.
Why shouldn't we just construe it as an argument made for the first time on appeal? Just a plain old error argument.
And that is a good question.
Did the defendant have the advantage of our case law when the briefs were being written?
I believe Wettrick was decided after the briefs were submitted.
No, our later case law distinguishing what the frozen moment in time of Murdoch 2 that we look at to determine whether a sentence is legal or illegal. I mean, this is the weird area of the law where a sentence might be legal under a motion to correct because it was legal at the time, but based on our equitable rules where we apply later decided law while a case is pending on appeal, this is arguably an error.
Right.
It's an erroneous sentence, even though it might not be an illegal sentence.
Under the motion to correct, all right.
And my position will still be it's presented as a motion to correct a legal sentence, and it was a legal sentence at the time.
Well, give me your best answer as to why we can't simply, based on the unique timing of all this, construe this as a, I mean, there might still be preservation hurdles. It's being raised for the first time on appeal, perhaps, but why can't we just construe it as a regular old claim of error raised for the first time on appeal?
I would say because it's not preserved, because it was not objected to below and not then added as part of the direct criminal appeal, and it was not taken up at the time. So I think that's my best argument. As far as the 6455 evidence goes, I believe it was appropriate to leave out the non-issuance of an information. I think the primary reason for that is any statement about that ultimately comes back to a individual, in this case the Florida prosecutor's, ultimate determination of the credibility of witnesses and the case itself, and all of that evidence would be inadmissible. So the no charge being filed in Florida is not relevant. The fact that he wasn't convicted of anything was still before the jury, and the fact that he denied having committed the crime in Florida was still in front of the jury. So the ultimate disposition that it was disposed of with the prosecutor not filing charges or filing a formal no charge letter is how it happened in this case, is not relevant.
I'm struggling with this one. It just seems like a goose and gander situation. If the state gets to put in that he was a suspect, but he doesn't get to put in that that suspicion didn't rise to the level of a case, I don't get that.
Well, because again, I think you beg the question, where do you go from there? If a case isn't filed, you would presumably the prosecutor of our case in Kansas could call the prosecutor of the case in Florida to say why he didn't file it. And in that case, you start getting into a lot of inadmissible evidence. You start getting into the prosecutor having to explain, like, we believed these witnesses, or even just making other statements that might be even more prejudicial, like there was other witnesses but they disappeared. So I think it just it opens the door to too many things that are just not relevant. A jury verdict, I think, is a unique situation that is presented when we talk about out-of-state offenses. So I do want to move on to the primary issue, which is the felony murder, whether felony murder should have been instructed. The state's position is that this court should adopt Judge Atchison's dissent as the ruling in this case. I find this scenario to be somewhat interesting because if you present different factual scenarios, then there is arguably no change in what happens. If the jury had been instructed on felony murder in the alternative of first-degree premeditated murder, the jury could find him both guilty of first-degree felony murder and second-degree intentional murder because they are not the same crime, they're alternatives. And because second-degree intentional murder is not a lesser-included offense of felony murder, routinely juries can return a verdict of guilty on both. It's because they're not instructed as lessers. And in that case, typically we only allow someone to be convicted of a single count. So the state would elect arguably to go with felony murder, but there's nothing. In this case, you put this odd scenario, what if the jury had returned a verdict for both? What's to stop a jury from returning a verdict for both second-degree intentional murder and felony murder? They're not the same crime. They are not lesser. One is not a lesser included offense of the other. There's a multiplicity issue that arises, but that's post-conviction. That doesn't affect the jury's ultimate verdict. That would be a court deciding which count is the actual count that he would sustain the conviction on. And so because of that, the idea that there could ever be a scenario where you forced the prosecutor to file a felony murder count when first-degree premeditated is their operative theory becomes almost ridiculous. And I also think that there presents an issue where the ADO is arguing that essentially jeopardy will apply because they're the same crime, but if we take double jeopardy in terms of the classic idea of concordance of elements, concordance of actions, felony murder and first-degree premeditated murder do not have a concordance of elements. They require different elements to be proven. One element does not prove another element, so they are different. They are, for all intents and purposes, under our classic breakdown of double jeopardy, separate crimes. And then I would also argue that this last week, the court published a case in which it argued that Jessica's Law cases and cases involving minors between 16 and 18 or 14 and 16, I'm sorry, I'm getting the years wrong, are not lesser, one is not the lesser included of the other, and a jury was not entitled to be instructed on that. I think this is very similar. We're talking about two crimes in which the elements are different. So the idea that the defendant was somehow prejudiced because felony murder was not instructed or that he was entitled to the instruction is just not a factually accurate statement. And it also creates some very strange legal results. So I would argue that Judge Atchison provides the best answer, which is the prosecutor has discretion to file what charges it wants to file. Other than lesser included offenses, which must by law be instructed to a jury, if something is not a lesser included, it cannot be mandated that it be instructed to a jury. And I think the ADO talks about how these create alternative means, and my answer to that would be this court has instructed prosecutors for several years now that if you have a case with a statute that creates alternative means and you don't prove all of the alternative means, it is your responsibility to elect to the jury what you're putting in front of them. And so this court has already, if that's the way that they're approaching it, that it's an alternative means of committing murder, this court has already instructed the state that we are to opt for the alternative means that we believe are proven.
I think that's confusing multiple acts and alternative means. We have an elect or instruct rule on multiple acts, but not on alternative means. Then you have to prove all the means.
Right.
Yeah, okay. That's the point. That's his point. So, anyway.
Right. And I think that based on all of that, there is no precedent for, while Young does provide a situation in which felony murder was instructed by the court and that wasn't an error, that is different than saying there is a circumstance that the court has ever found where felony murder must be instructed or it is error. And I don't believe the court should find that to be the case, and I believe Judge Atchison provides excellent reasoning for why it isn't the case. And I would ask that you adopt his ruling, adopt his dissent, reverse the majority as to that point. And then I would also ask that you reverse the majority as to the finding that not instructing the jury on the no information was an error. Even if you don't buy my argument, I do believe I do side with the Court of Appeals that it was harmless error. And then as to the issue presented by the Florida burglary, I would say that I would ask that you apply Williams, that this does get treated as a motion to correct a legal sentence, and it did. We are in the post-Murdoch II world where the sentence was not illegal at the time it was imposed. And if there are no other questions, that's the extent of my argument.
Do we have any further questions? Thank you, counsel.
On the Buell issue, so the timeline is basically correct, that there was sentencing, and he was sentenced on the day Dickey came down. And so the next week, counsel was like, oh, hey, look at this. So he files a motion to correct a legal sentence. And the judge court held a hearing on that and said, no, Dickey doesn't apply, and the Compton applied, these other cases, and they filed a notice of appeal. But that notice of appeal was never docketed. The notice of appeal from that hearing was never docketed. And so when I get to my brief, I'm looking at this, and it doesn't seem, I mean, I suppose I could dock it at a time, that happens, but I explained this to the court, that this is what happened, but I specifically raised it as an issue that was being raised for the first time on appeal. And so in my mind, the way I looked at it is that although those arguments were made to the district court and you have those findings and everything, the motion to correct, I basically abandoned the motion to correct the illegal sentence because it hadn't been docketed. It was after the other one. So that appeal hadn't been docketed. And I raised it as an issue raised for the first time on appeal, which I understood I could do under Dickey. And so to me, we're not proceeding, and I also, we're not proceeding under a motion to correct a legal sentence, Mark 2. I think it is a critical distinction that if the motion to correct a legal sentence happens during the direct appeal, and this court is considering that during a direct appeal, because otherwise, essentially you'd be punishing this defense counsel who I think was trying to do the right thing. His client had already been sentenced. He files a motion to correct a legal sentence. There's this new law out there. I want this applied to my guy. And to say that if you do that, then you're abandoning the rule that you get the benefit of any change in the law on appeal, I think would be unfair. And so those are the two reasons that I think this court can consider.
Do you concede under Murdoch 2 that on this issue the sentence was not illegal when pronounced? Because it was pronounced prior to Wettrick.
It was pronounced, so
it was legal when it was pronounced.
It was legal under Wettrick. There may be some concept to comp and all of those type of issues that have yet to be decided as to whether or not the statutory scheme then survived constitutional muster. So I guess no, I would not. I would say that Wettrick and Buell were not the law then. I would concede that. But I think it would still be, I guess, on a motion to correct a legal sentence. I mean, I guess that's the question I don't understand.
Well, you're making a Wettrick argument, right?
That's
That's the foundation of your argument.
That's right. Yeah,
To cut to the heart of it, how is that argument preserved?
As I understand it, you can raise a criminal history challenge at any time.
That's under the motion to correct an illegal sentence. The
No.
at any time language is...
Well, right, but I thought there was also the language under the criminal history, 6811. I thought that it said that you could challenge an incorrect criminal history score at any
direct
time.
appeal.
A what?
On direct appeal.
On direct appeal. I thought that was a language in separate and apart from the motion to correct legal sentence, that as part of there was a special criminal history challenge. So I think.
So you're relying on that to say that my argument's preserved.
Right, and I also think there is just sort of a general fairness of if it wasn't the law at the time of the sentencing, and then it later becomes the law, it seems, again, sort of unfair for the trial attorney to say, well, you didn't raise, nobody knew that was the law at the time, but you didn't raise this, so you don't get the benefit of that law then. It seems like if it's your direct appeal and the law has changed, you get the benefit of that law. That seems fair to me.
That's why we have that rule.
I would think, that's how it's...
And our rule, that is the rule, but
Yeah.
that doesn't absolve you of the obligation to show why it's properly in front of the court in the first instance.
Sure, that's right. And I would say that the fact that it wasn't the law, the reason why it wasn't objected below, that there's an excusable, I don't know if you call it neglect, but there's a valid reason why it wasn't raised below and that it wasn't the law then.
Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.